Hello there. This is Dr. J. Kent Gregory, and I'll be taking you through Chapter 1 of The Legal and Ethical Environment of Business by Terrence Lau and Lisa Johnson, published by Flat World. So, Chapter 1 is the introduction to law, which is fitting. There's a lot of information in this chapter, so we'll break it down into the high points, but even though high points is what we'll be hitting, uh, this will be broken out into two, maybe three videos. So theories of jurisprudence. And jurisprudence is the philosophy of law. So one of the theories is legal positivism. The legal positivism is essentially the belief that the law is whatever the sovereign says it is. So the sovereign can be a monarch, or it could be, the government, could be the president, something like that. So laws are written, human-made laws, and the law must be created by legitimate law-creating authority. But it's whatever the sovereign says it is. Um, the next theory of jurisprudence is legal realism. This is a belief that law itself is less important than who is in the position to enforce it. So the criticism of that theory is that individuals in position to exercise the power of law over others should not circumscribe the checks and balances of the government. So, in essence, with legal realism, uh, he, she, or it that is in power or who is in the position to exercise the power over others could do that. And so that would be a problem. And then another is natural law. So this is the belief that humans possess certain inalienable rights that are not the products of human-made law. And I want you all to think about all three of these and how they manifest themselves in various laws that we'll study, but also in the Constitution, the Constitution of the United States, as well as some of the other sources of law that we'll look at, like the Code of Hammurabi, the 12 Tables of Rome. Briefly, we'll make mention to the Magna Carta, etc. Then there's legal practice, and this emphasizes the context of disputes or facts, questions the foundations of law, and recognizes that alternative perspectives are unavoidable. So to sum up, in a way, law should be viewed as an instrument and as a practice, and the facts of a case should be understood in their context. And of course, this is Edward Snowden right there. So the key takeaway is that different theories of jurisprudence inform our understanding of what the law is. And so examining legal issues through the lenses of different theories of jurisprudence allow us to see how different outcomes can be defended. And of course, this is exactly what attorneys do in court or when they're negotiating on behalf of clients, say in a civil case. Classifications of law. So there are four essential types: public law, and this is law that applies to everyone; private law, and law that's legally binding on the parties that agree to it. So for something like this would be a contract. And then procedural law. These are the legal rules that must be followed by government officials in the execution of law. And then finally, substantive law, the actual substance of the law or the merits of the claim, case, or action. So to compare criminal and civil law, we'll be going horizontal here. Criminal law is law related to conduct that is prohibited by the government. Civil law is all law that's not criminal law. So in criminal law, the criminal charge is prosecuted by the government, whether that's uh, local or national. So federal versus state, or federal versus city. And then civil law is civil claim is pursued by a plaintiff. Uh, in this one, attorney is provided for the defendant if if the defendant cannot afford one. This is under criminal law. In civil law, the plaintiff has to get his or her own attorney. And then criminal law, there are penalties for violation, and these include incarceration or loss of life. Whereas under civil law, penalties for violation include monetary forfeits. Basically, you pay a penalty, or if you lose your case, you owe the person that you were suing money. Primary and secondary sources of law. So primary sources are the actual laws themselves. These are constitutions, statutes, and importantly, judicial opinions. And then secondary sources of law are interpretations of law. So these could be restatements of law, law review and journal articles, uniform codes, and treatises. Uh, so they talk about a treatise here, an exposition or summary of an area or body of law. And then there's the Uniform Commercial Code. Uh, so this is a model statute that seeks to provide uniformity to contracts uh, or contract law among the different states. So we'll end with the U.S. Constitution and the Bill of Rights. Hopefully this is all very familiar to you all. The U.S. Constitution is the supreme law of our land. It created the structure of the U.S. federal government, which consists of three branches: legislative, executive, and judicial. So those are the three branches. And then the Bill of Rights are the first 10 amendments to the U.S. Constitution. And essentially, the Bill of Rights state that any powers not expressly granted to the federal government are reserved to the states, and it preserves individual civil rights and liberties. So we'll end there with part one of chapter one, and we'll pick up with state constitution.